schedules which will allow consumers to make more informed decisions. The cooling off period will allow borrowers to rethink a decision and correct it if they change their mind. Now, what this means in the legislation is that borrowers have until the close of business the following day to end the contract without penalty. Allowing the borrower to cancel a payday loan at no cost if the lender doesn't disclose the borrower's right to cancel should act as an incentive for the lender to ensure that they do inform the borrower properly. Mr. Speaker, consumers will now be protected from being overcharged or facing the unexpected costs. And Mr. Speaker, with those few comments, I will move second reading of Bill number 87, the Consumer Protection Act.
Thank you. The honourable member for Waverley Fall River Beaver Bank.
Thank you, Mr. Speaker. I rise with respect to this bill, Bill number 87, with some mixed feelings. I certainly want to acknowledge the minister and certainly his department for recognizing the need for payday lenders to have some sort of regulation in the province of Nova Scotia. Obviously, similar to other parts of Canada, there is a demand for the service of payday loans. That in itself indicates a need for protective measures as far as the consuming public is concerned. Mr. Speaker, in the case of the majority of payday loan customers, I don't know the statistical demographics of who supports and who caters to payday loan companies, but I would suspect they don't resemble myself or you, Mr. Speaker. The demographic does probably resemble some of those that are in financial need at a time in their life before they get that next paycheck for some immediate financial relief. I would think that these individuals place themselves at some risk and at some hardship, Mr. Speaker, with respect to having in their own minds, and I'm certainly not going to judge them, but in their own minds, they've come to the conclusion that they have to visit a payday loan vendor. I would even go further to suggest, Mr. Speaker, that to a large degree, and again, I have no statistical data to support this, but I would suspect to a large degree, even these individuals from our society that are going to the payday loans probably are the ones that probably can ill afford it the most, with the high interest rates and the existing terms. I also see that they've probably met some bumps in their lives, or there could be some sort of hiccup in their life, an immediate one, that would force them to seek out this financial relief that payday loans do offer. I see Bill number 87 as a necessary first step, and I want to reiterate and stress, I see it as a first step, whereas consumers need to be protected from offensive interest rates and rollover hardships. Not only do I see this as beneficial to the consumers, Mr. Speaker, but I also think that from the area of protection for those payday loan companies that are existing, that they would want some sort of regulatory, policies and procedures in place, because it would protect them from the fly-by-night organizations and groups that are going to pop up, and I think that have been popping up all over the country. It gives the payday loan lenders, I would hopefully, some added credibility, some responsibility, and it would reestablish them on some moral higher ground than what they stand on now. We can't ignore the increasing demands. It's my understanding from statistics, certainly that payday loans are popping up at, I guess to me, at an alarming rate, not only here in Nova Scotia, but right across the country of Canada. Government will see this, and I think that government recognizes this and has seen this bill as a way of and I almost hate to use the word control, but having some sort of regulatory, I guess, and I will use the word control, over payday loan lenders, and also at the same time providing some protection to the consumers. And again, I've already mentioned the first step in the process, and I think it's we haven't hit the home run yet with respect to this bill, but certainly we've gone more than just being up at bat. This bill will provide some accountability and responsibility for on the part of the lenders. I recognize for the most part payday loan lenders, I think, are professionals. I think they would, and I'd like to think that they are ethical. And this bill only further enhances and reinforces the ground of moral obligations that we would want companies that reside here and take up residence here in Nova Scotia that will aspire to and reach for. So it is it's probably with those things in mind, both from the consumer perspective and also from the business end of things, is that I see this as not the home run, but an important first step. Thank you.
Thank you. The honourable member for Halifax, Clayton Park.
Well, thank you very much, Mr. Speaker, and I'm happy to rise today and speak on second reading on this Payday Loans Act, which is before us. I believe it's Bill number 89. Mr. Speaker, the concern we have is certainly for consumer protection, and it's for people who are really vulnerable in our society, who don't have enough money to go from paycheck to paycheck. They don't even make it to the next paycheck, which we often say many people live paycheck to paycheck. And when you see where the payday loan operators are, where those businesses have sprung up, and as we know, they've sprung up and become a huge industry in about the last 10 years, they're generally in areas where people are more vulnerable, where they have less economic advantage, and so on. And so our concern would be, Mr. Speaker, that those people who need to depend on this service, and it is in fact very important to a lot of them in order to survive, is that they be given the best information, that there be clarity around what the costs are when they seek this service and are able to get these small loans advanced to them, and that the industry not be taking advantage of people who may not have the financial sophistication of others, may not know about the interest rates and so on that are being charged. Really, the bill itself, is the right thing to be doing. It coincides with legislation across Canada, which is in tune with some legislation, I believe, federally that had to change. The reason being that these loans are for such a short period of time that when you looked at their annualized interest rates, they were above the rate that was allowed under federal legislation. I guess it would be called usury or outrageous interest rates, which another financial institution would not be allowed to charge if you were taking out a loan. But the reason for this is that these were not being called interest charges, they were fees, essentially, for the service of offering a short-term loan. So the federal government has adjusted their legislation, and now individual provinces are coming in line and trying to adjust to that situation and really recognize, I would say, fundamentally recognize, Mr. Speaker, the need for this industry that has sprung up, and that it is unique from other financial institutions. And I think the key thing here, there's a couple of key points in the legislation, but number one is there's now going to be no rollover loans will be allowed. And rollover loans are where you've taken a loan based on your next paycheck that you were to pay back within a couple of weeks' time, but in fact you're not able to pay it off, so an extra charge is added on and we roll it over for another 2-week or 3-week period. And that was a way that people were getting hopelessly behind, because the fees each time it rolled over were greater. And what was intended to be just a short-term loan ends up becoming a much longer term, and the costs rise exponentially. And so for that reason, Mr. Speaker, that was very damaging to people that, as I say, the people that are needing to turn to these very short-term loans in order to make it to the next payday. And I think the fact that those will now be prohibited is a big improvement, because really when the industry is operating as it should, it's just a way of lending money for a short period and being able to pay it back when you get paid. And there shouldn't be extended periods of time, and that's also being covered in this legislation as well. So I think overall, our major concern is that there be very good explanations and advertising of the information about what these loans are costing you. And Mr. Speaker, I believe that will be covered now in the Act, so that anybody who is legitimately having one of these businesses, and as I say, there are something like 800 in Canada. There's a good number of these that are in business, and I think that the vast majority are ethical, and they care greatly about the people that they are there to help. And so what we want to ensure is that all of them adhere to a high standard of conduct. And in fact, Mr. Speaker, it's interesting to note that there is an association, a national association of payday loan companies, and they have done just that in terms of trying to increase the professionalism and code of conduct for all of their members. And the majority of companies that are in this business are in fact members of the National Association, although not all of them, but the majority are. And for this reason, I think even among the industry itself, they are making every effort to set a high standard and ensure that their members behave in a way that will support communities and not cause problems that would lead people like ourselves in the legislature to need to step in and make rules that would have to guide their behavior. They would like to do it themselves voluntarily and set a high standard. And a lot of the changes that are proposed in this legislation, I believe, come from the Code of Conduct and Ethics that the industry itself has laid out. So in fact, they're providing some of the guidance themselves, and they are not in any way opposed to stricter regulations on the entire industry. And that is because they themselves realize the future of their businesses depend upon, I guess, society as a whole being comfortable with the service they're providing and understanding that they are acting in the best way possible and protecting the people as well that are their customers. So I think the fact that we're now limiting, in fact, eliminating the rollover of loans and ensuring that there is very clear advertising at the point of sale, so to speak, at the offices themselves, that will explain very clearly to any potential customer what the cost is. I believe those things will protect customers and the consumers in this case. So, Mr. Speaker, with that being said, we look forward to seeing if there are any speakers that come to law amendments on this bill. And we certainly are, at this point, very, very supportive of the fact that it is, in fact, lining us up with other provinces, aligning us properly with the federal government, and I believe overall it will provide greater protection to consumers. Thank you, Mr. Speaker.
Thank you. The honourable member for Dartmouth North.
Thank you, Mr. Speaker. I take great interest in having this bill come forward today for second reading. I want to thank the minister responsible and the government for attempting to address a very, very important and crucial situation right across Canada, Mr. Speaker. I'm going to table a document from the Canadian Payday Loan Association, but before I do so, I just want to read a quick quote as to what actually a payday loan in their terms means. A payday loan is an unsecured short-term loan to meet unexpected cash needs. Payday loans are for occasional use only and should not be used to cover continual shortfalls in a person's budgetary requirements. People who are having ongoing problems meeting their financial obligations should be consulting credit counselors. And I'll table that, Mr. Speaker. This bill, as has been mentioned, goes a long way in accordance to many legislation, or much legislation that's taking place across the province, or across Canada, sorry. that will come in line with the bill that's currently before Parliament. I think it's important to understand that. But Mr. Speaker, I think the fact that it's actually 1,400, over 1,400 of these payday loan establishments are in place across Canada. And I think in saying that, looking at the business aspect of it, I have to ask myself why? Why have we seen such an influx of these payday loan businesses, not just across Canada, but particularly in this province? And I'm quite alarmed by it, Mr. Speaker, because the constituency that I represent, there is a great divide between the well-to-do and the not-so-well-to-do. And as my honourable colleague from Waverley Fall River Beaverbank stated, he doesn't have the stats or the demographics as to who uses these. But I've done some research, and I've visited many of these locations, inquiring as to the process that someone would have to go through to apply for loans. I've spoken with many people that do indeed use the financial institution or measure of getting through. I believe the demographic that are being poisoned by this institution or form of lending right now, Mr. Speaker, is the working poor, those that work paycheck to paycheck. An even larger number surfacing in our province now. 50% of this province earns less than $25,000 a year, Mr. Speaker, and those are the ones that find themselves in need or unable to go to a bank for a small interest loan. And actually, when we talk about the mainstream financial institutions, they can't compete with these payday loans peoples. But I stand here today in my place, Mr. Speaker, because I'm concerned about not just the processes that these lenders take, but those people and the protections that are in place for them to use when they come or find themselves in need. Mr. Speaker, I will look at, and I want to go through the steps, as was told to me many times by several constituents, as how they've gone about getting one of these payday loans. The process, once you walk through the doors, what they actually go through, what's required of them. And what happens, Mr. Speaker, is you walk in, you deal with the teller asks for certain informations. And I'm going to table, again, from another payday loan institution, another document. And this is what they consider, or how they consider whether or not you qualify. All you need to qualify is a steady source of income from employment and a personal checking account. And you can get in advance up to 50% of your net pay. And all you have to do is bring in a personal check, your most recent pay stub, and an updated bank statement with a valid photo ID. And I'll table that, Mr. Speaker. Thank you. Now, I can tell you that it all sounds great. And with this legislation, it's going to, I believe, lessen the numbers. Because I think really that's what the industry wants, or the industry leaders, the larger organizations that are offering up these payday loan services. This is what they are pulling for legislation, Mr. Speaker, because what they want is the smaller institutions out of the way. And I can tell you right now, Mr. Speaker, I can walk down Wise Road in Dartmouth North, and I can see on one side of the street an industry leader, let's say, Mr. Speaker, a payday loan industry leader. And I can go across the street to the local shopping center, and I can see a not-so-formidable leading institution leader in the payday loan business. And the difference, Mr. Speaker, is that the smaller person or the smaller individual who's seeked out this opportunity to benefit or extend this service to the consumer doesn't have the same set of values, Mr. Speaker. They don't play by the same guidelines or have the same rules in place. And that's unfortunate, Mr. Speaker, because I'll tell you what happens to people that use these payday loan companies, okay? It's not check to check. An individual can go in and apply for the loan, they receive the loan, and in 2 weeks' time or a month's time, they end up going in and they pay off their loan. The problem is, Mr. Speaker, due to the interest rates, and no matter what interest rate the URB sets for them, that individual, those individuals that seek out this service, are now short on their paycheck. And in many cases, and in most of the cases that I've dealt with, the individuals I've spoken to, Mr. Speaker, Usually what happens is they end up, the day they pay, borrowing again from that payday loan individual. And I'll go back to some of the brochures that I've read and some of the individuals that operate in the industry, Mr. Speaker, and I can tell you that there are guidelines that state they want payday loan lenders, if you default on a loan twice in a year, they will recommend seeking counseling, Mr. Speaker. Well, this is great. But, Mr. Speaker, I have a bigger problem with somebody that is continuously using this service. And I'll go back to the document that I first tabled from the Payday Loan Association that stated it is a short-term loan for short-time chaotic situations that you're dealing with that come about, not a continuous form of borrowing, which a lot of these individuals that seek out this service find themselves doing, Mr. Speaker. So I guess looking at the legislation, it's a wonderful step. It's a positive step. Is it all we can do? I think we're keeping in line with what's going across Canada right now and what's being formed in Parliament, but I think we can do more, Mr. Speaker, and we have to do more, not just to make sure that these payday loan lenders are online, but we need more protections for the consumer against themselves, Mr. Speaker. It's not just the working poor, Mr. Speaker, that are using this service. I know many, many constituents of mine that are on disability pensions, old age pensions, that now seek out this service. Due to the rising costs of everyday living, Mr. Speaker, they find themselves short. Even at the end of the month, when that check comes in, when that senior receives their check, that money is usually gone within a week, Mr. Speaker. And if they're not seeking out the services of the food bank, they are seeking out the services of these payday loan lenders. And Mr. Speaker, again, come the following month, when that check comes in, that individual walks into that payday loan lender and they pay off that loan. But guess what, Mr. Speaker? They're repeating that cycle. And that's what's scary, Mr. Speaker. And I'm telling you right now, when you owe someone, when someone's breathing down your neck, it's not a good feeling, Mr. Speaker, especially for our aging population that are more increasingly using this service. How do you break the cycle? How do you break the cycle? Are we going to rely on the payday lenders to educate people, to stop them from having that second consecutive loan like we would hope? Because when an individual goes in on a continuous basis, Mr. Speaker, that's telling me, or that would tell me that this person has a problem, that this person isn't budgeting their funds, that this person should seek out counseling. And right now, I can tell you, across the industry, Mr. Speaker, I don't believe that is happening. And I think an amendment could be brought forth, or should be brought forth. Again, that's just one step that we can take to further protect the consumer, Mr. Speaker. I want to, I want to touch on families right now, Mr. Speaker. A lot of families have been affected over the years by addictions to alcohol, to gambling. And Mr. Speaker, with those that deal with these addictions on a daily basis, I think I'm stepping out on a limb. Maybe I might be a little harsh, but I believe that the payday loan lender situation is the crack cocaine for the working poor. And when I say that, a lot of times what happens is the number one cause or big contributing factor in marital breakups and family disputes and relationships is financial. A lot of situations I've had to deal with or have come in contact with, a certain member of the family goes out and borrows money from a payday loans. The following week they pay it off, their paycheck is short, Mr. Speaker. There's bills to be paid. The other member of that relationship finds out, Mr. Speaker, and it doesn't settle too well. So we have a huge issue, Mr. Speaker, and without citing names, but I've come in contact, and I am in contact with one of these lending institutions. Right now, currently, I'm awaiting a visit by a regional manager from the Maritimes to rectify a situation that went wrong. A gentleman that was on a military pension had been left on his own. His wife went off for a weekend away, and he sought out a payday loan advance. because he didn't want to be home without money. He was dealing with depression, whatever. He goes out and he gets the loan, Mr. Speaker. In a week's time, when the wife comes back, there's a barrage of anger. There is a barrage of verbal slings, Mr. Speaker, from the wife to the husband, and the wife trying to explain, how can you do this? These people are vultures, Mr. Speaker. And the husband trying to explain to the wife, I needed money, I needed food, I had to have something in the house. I was lonely, I was depressed, Mr. Speaker. I can tell you what happened, Mr. Speaker, is that the wife went to the payday loan lender, paid off, which some payday loan outfits do. They will allow you a certain fee if you are able to pay it off before the date is due, Mr. Speaker. And to those that can afford it, okay, for those that can afford it, it is a minimal amount of money. And it's logical, Mr. Speaker. But what's not logical is that most people that are using these services, Mr. Speaker, aren't able to come up with that money beforehand. They are indeed waiting for their day that they get paid to go in and pay and then borrow again. But this particular case, the individual went in and paid off that loan early. And then was told there was an additional fee if she wanted the check back, Mr. Speaker. An additional fee to have the check that was post-dated. Now, she's paid off the loan. I don't understand where the additional fee came in, and therein lies the problem with some of these institutions. But where I came involved was because of the research that I've done, Mr. Speaker, and knowing that some of these institutions actually charge a minimal fee of $4 to $6, let's say, Mr. Speaker, if you indeed pay off early. This particular payday loan lender took advantage of the individual. She went in, and of course, Mr. Speaker, she was in a rage. She was frustrated. Never lend to my husband again. I don't want to ever see you do this to my husband again. Mr. Speaker, these people took advantage of this lady because she indeed paid off this loan 6 days early, Mr. Speaker. And when I meet with the regional general manager, it's not to see or understand or better understand his operations, Mr. Speaker. I want that money back for those people. This institution, I won't even call it an institution, Mr. Speaker, because these payday loan individuals are taking advantage. They aren't providing a service, Mr. Speaker. This is not a service that Nova Scotians shouldn't have, or people across this country shouldn't need to seek out, Mr. Speaker. And I'll tell you something else, Mr. Speaker. Something else that bothers me when, excuse me, when you get caught up into the cycle of using payday loans, and that check goes through to your bank account, Mr. Speaker, the bank now knows what borrowing habits you've been doing. And when an individual who has a regular job, but who is continuously on a weekly or bi-weekly basis or a monthly basis is using this service, Mr. Speaker, and those checks get processed and sent through his account, and if that gentleman or that lady needs a loan for a vehicle, needs a mortgage on their home, seeking out advice for tuition, their standard financial institution, recognized financial institution, now knows, as we all know, they know where our money goes and how we spend it. One click of the button, Mr. Speaker. They now know that that individual has unsavory borrowing habits, Mr. Speaker. Can't help you. Can't help you. Something catastrophic happens, you have to go to the bank for a loan, be it medical costs, be it vehicle damage. You need repairs on your car, and you go to the bank, and the bank says, well, you know what, it's fine. It's fine. We'd love to do this. But let me ask you about this. I see a trend here. Every 2 weeks, this check going through. And they know where it's coming from, Mr. Speaker. And that there's an alarming amount of people. If we could possibly do it, and I don't know if we can, Mr. Speaker, we have to honestly ask ourselves, why do payday loan institutions come to Nova Scotia? Why? 50% of the province makes less than $25,000. Standards of living, Mr. Speaker. People are in a pinch. And these people, these lending institutions, are predatory. Some of the brochures, Mr. Speaker, when you go in to these institutions, and I've pulled many of them, some of them aren't even written in both languages. And over the last few weeks in this House, we've talked about literacy. We've seen the federal cuts to literacy. Adult literacy, Mr. Speaker, those people that can use these services. I have to question these payday lenders and the people that work for them. Are they prepared to go through an application and actually word for word spend and make sure that that person that's borrowing that money understands fully the repercussions of the step that they just took? And Mr. Speaker, if we could legislate that, I would feel more secure. But again, I'm not here today, standing here today in my place, Mr. Speaker, in favor of any of these lending institutions. Again, I'll say it's the crack cocaine for the working poor, and not just the working poor, but seniors who are constantly in a pinch at the end of every month. When that check comes in, it's gone. 1,400, Mr. Speaker. Over 1,400. Is this legislation going to rid ourselves, rid our societies, rid our provinces of some of them? Yes, it will. Absolutely. Because the small guy in the pinch, the vulture that's seeked out to take advantage of an industry that was blossoming, growing at rapid rates, because people across this country and across this province needed that extra little bit to get by. Those are going to go, Mr. Speaker. They're without a question. And the faith that I put in the URB, okay? I want to go back and touch on the business aspect of it, Mr. Speaker. The URB comes down and it's going to decide what interest rate these financial, or no, I apologize, Mr. Speaker, these lending institutions are going to impose. What's it going to be? They tell us that we have to charge enormous amounts of interest because of our overhead. 20% of it is actually profit. 40% of it, 30% of it is for wages and salaries. So the URB comes out with a decision and says, we're going to offer you a 30% interest cap. That's it. That's what we're going to charge. Okay, 30 is better than 60. But Mr. Speaker, to an individual that is barely getting by, living paycheck to paycheck, when that loan comes due, when that 30% is off the top, I'll ask you, where does that individual go? Is he in a better place because the URB said 30 instead of 60? I have to beg differ. I believe that all governments across Canada should strongly, strongly look as to what the legitimacy of allowing these payday loan companies to set up in our provinces. Why? Let's go in and ask them exactly why. What is the benefit, Mr. Speaker, to those that use this service? I don't see any. I'm in a pinch. I need the money. But again, it's crack cocaine. Oh, geez, that's great. I got a little bit of money. I can get ahead a little bit. I can pay a bill up. Sounds great. But I'm in again 2 weeks' time, and I'm borrowing off that person. Bigger issue, Mr. Speaker. Bigger issue. Unless I win a lottery, which we all know the odds of that, or perhaps I go through a cycle of a whole year and I get my income tax back. And by gosh, Mr. Speaker, I can breathe again because I can break the cycle. I can go in and I can pay it, and I can stay away from that individual payday loan company for a certain period of time, Mr. Speaker, because the temptation's always going to be there. Income tax doesn't last long. One of the bigger issues I think that's out there actually, Mr. Speaker, right now is the fact that my honourable colleague from Clayton Park had suggested the rollovers, no more rollovers, legislation to eliminate rollovers, and that's great. That's fantastic, Mr. Speaker. But as I stated earlier, I can walk down Wise Road on one side of the street, and I can go see this gentleman, and I can go across, and I can see this lady. And where is the communication between the two? When I walk in, I can go in and say, here's my pay stub, here's my ID, here's my recent bank statement. I need to borrow this much money. Thank you very much. I can go across the street and do the very same, Mr. Speaker. I can drive down the road and I can hit a third one, Mr. Speaker. And Mr. Speaker, as I stand here today, I can tell you that I have known and have met with, in the short time I've been an MLA, half dozen, and these are seniors, Mr. Speaker, who are running scared. Individuals who have sought out the services of these payday loan companies one at a time. And they're on a rotating basis, Mr. Speaker. That's the kind of legislation I'd love to have put in place. Communication in amongst the individual payday loan lenders, Mr. Speaker. Because I'll tell you right now, when you have a senior citizen walk into your office and say, I've changed my number. Well, what for? I've changed my address, Trevor. Well, I owe this guy. And I'm scared because I owe this guy. How do you get in a cycle like that, Mr. Speaker? Where is the advice that the Payday Loan Association of Canada says? We will tell you, we will inform you that you should seek out counseling, Mr. Speaker. What I have are seniors running around scared because they owe these companies money, because they've fallen into the addiction, Mr. Speaker. They've hit rock bottom, so much so that they had to go to another one to get rid of one, but they didn't, Mr. Speaker. 2 and 3 at a time. And what happens? Well, when you're 65, Mr. Speaker, credit doesn't really matter. Chances are you're living on a pension that barely affords you to live. So if I've taken somebody 2 or 3 times, well, I got ahead, I'm a little scared, well, I don't really care about my credit. And that's what they'll tell you, Mr. Speaker. They'll call you, they'll inundate you with phone calls. We all know what it's like to go through credit. But to have a senior citizen running scared, changing their address, changing their phone, relocating, running away from these predators, Mr. Speaker, I am very uncomfortable with that. Very uncomfortable. It's a positive step that we take here today in moving this to second reading. It's absolutely no question. But to merely do it without the full understanding of what an individual goes through when they use or seek out this service is turning a blind eye to the real effects and the real reasons why these individuals come to our provinces and seek out the people that need these services. They take advantage of them, Mr. Speaker. We can't merely fall in line because the rest of the provinces across Canada are coming together and saying, oh, well, we have a big problem here. Let's look at the real issues. Let's investigate and see, as I've done, Mr. Speaker, as many people who's walked through my offices and taken me through the process, because it's an understanding that you really need to draft up the type of legislation we need to really protect the consumer, and not just against the lender, but against themselves, Mr. Speaker. And it's a hard step to take. You go back and you talk about addictions, gambling, Mr. Speaker, even the Lottery Commission. Even the Lottery Commission can't assist as they try to, their efforts and attempts do with some of the monies and profits that come through that form. An individual has a habit. They know that the cash is available, Mr. Speaker. I need money for the weekend, Mr. Speaker. These are not ordinary situations. When these organizations come to our province, they have to understand the individuals that they are going to deal with. Are they going to benefit them? Are they helping them? Are they getting them through a chaotic situation, Mr. Speaker? Now, sadly, not the people that I see that are using them. Sadly, not the people that I see. It's a positive step, and I stand here today, as will the rest of my caucus colleagues, in support of the legislation, in support of the bill going forward, Mr. Speaker. Am I happy? No. Does it matter? Yes, it does. To me, it matters, Mr. Speaker, because the individuals that are being affected by these services. Eventually, Mr. Speaker, all 52 MLAs that reside in this House at some point will have to deal with a situation where someone went overboard. When someone fed an addiction because they had the monies available to them through one of these services, and they've gambled away their home. Or they've given into their addiction to alcohol because they needed money for the weekend, the bills had to be paid, but the money was there. Am I for this legislation? Absolutely, Mr. Speaker. Do I think we can do more? I think we should seek out more, Mr. Speaker. I think we should work with our federal colleagues and the good provinces like Manitoba, who more than often bring out great legislation that we really should look at and adopt. Let's work with those individuals and seek out those individuals that are using the service. Why? Because if it's all about profit, Mr. Speaker, I can't stand here today and say that I'm happy. Because when you put profit over people, all 52 of us in here at some point are going to have to deal with that social situation that's going to walk into our office. And we all know that 80% of the cases that we deal with are social issues. And when you talk about the working poor, paycheck to paycheck, and seniors, Mr. Speaker, I have to take issue with that. Can I change it? I'll advocate for it, Mr. Speaker. I'll continue to speak out for it. Make sure that when legislation comes through, when it's drafted up, we actually know and understand the ramifications, who it applies to, and how it's going to affect them or not affect them, Mr. Speaker. I had posed a question earlier in the July session to the minister. Today he answered it. Legislation's going through, and again, I support it, Mr. Speaker. And with that, I'll take my seat. Thank you.
I'll recognize the Honourable Minister to close debate on Bill number 87. The Honourable the Minister of Service, Nova Scotia and Municipal Relations.
Thank you, Speaker, and I'd like to thank my colleagues on the opposite side of the House for their endorsement of the amendments to the Consumer Protection Act, and I look forward to our going to law amendments. And, Mr. Speaker, I'd now like to close a debate on Bill number 87, the Consumer Protection Act, and ask for the vote on second reading.
Motion before the House is for second reading of Bill number 87. Is the House ready for the question? All those in favour of the motion, please say aye. Those against, motion carried.
Bill number 87, entitled An Act to Amend Chapter 92 of the Revised Statutes 1989, the Consumer Protection Act.
Order that this bill be referred to the Committee on Law Amendments. The Honourable the Deputy Government House Leader on introduction.
Thank you, Mr. Speaker. I'd like to bring the member's attention to someone in the East Gallery, a member from Pictou Centre, a resident who has offered and volunteered his skills and expertise to many groups in Pictou County, including the Festival of the Tartans. I'd like the members to give a round of applause to Lloyd Tackard.
The Honourable the Deputy Government House Leader.
Thank you, Mr. Speaker. Mr. Speaker, I'd like to call forth Bill number 89, Provincial Court Act.
Bill number 89, the Provincial Court Act. The Honourable the Minister of Justice.
Thank you, Mr. Speaker, and it gives me pleasure to rise to make a few comments in regards to an act to amend Chapter 238 of the Revised Statutes of 1989, the Provincial Court Act. Very simply, Mr. Speaker, this bill allows for Nova Scotia to come in line with other jurisdictions in eastern Canada, such as, I believe, New Brunswick and Newfoundland, given the authority to the Attorney General under the advice of the Chief Judge in this province to appoint judges from outside this province to have the same powers in regards to trials and other matters of process. Mr. Speaker, I think all Nova Scotians would agree, an example such as language. All Nova Scotians should have the opportunity and the right to appear in court and to have their issues addressed in the language of choice, either the English or French language, Mr. Speaker, as they so require and request. So, Mr. Speaker, essentially this bill will address that issue. Again, something that other jurisdictions in Eastern Canada have addressed, and we think it's appropriate and very timely, Mr. Speaker, for passage of this bill. So with those few comments, Mr. Speaker, I would move second reading of Bill number 89.
Thank you. The honourable member for Cole Harbour Eastern Passage.
Thank you, Mr. Speaker. I'm glad to have a few moments to speak on this bill, Bill 89. You know, Mr. Speaker, this is a bill that in many ways addresses again something that I've seen in the last few years in this province, which is a recognition of the rights of Francophones in Nova Scotia to have access to services in their own language. I think particularly, I presume part of this is constitutional, since there's a constitutional right to a criminal trial in French. But I'm also assuming part of this may also cover civil trials as well, potentially, though that might be the devil's in the details. Either way, I'm glad to see the government moving in this direction. It's good for Francophones in this province. If there isn't enough Francophone judges or bilingual judges in this province who can hear trials, I would suggest that this is a very good opportunity to ensure that we do ensure if there's a backlog that it's being addressed. I would say in the long term, I would suggest to the government, and I'll put that on the record, that when they are selecting judges for provincial court, whether they be, I guess in this case now it's mostly criminal, though there may still be a few family appointments until we work out the unified court, Mr. Speaker, that they take into consideration bilingualism as one of the factors that they may want to use to ensure that the new judges that are coming forward as judges retire at the provincial level, Mr. Speaker, are judges that can handle trials en français. I think that would be good for Nova Scotia. I think it would ensure that we wouldn't have to be paying what are probably fairly excessive fees to bring a judge in from another province. I would also suggest that they may want to talk to their federal counterparts when they appoint judges to the Supreme Court of Nova Scotia, or the Nova Scotia Court of Appeal, or the Unified Family Court under the Supreme Court of Nova Scotia, that they also consider bilingualism as a factor so that we can be, as judges retire, through attrition, we can again have an opportunity to build up the number of judges who can hear trials in both languages. I think that's a good thing. I would hope the government would do that in the long run. I would encourage the Minister of Acadian Affairs maybe to talk to his colleagues about that. In the meantime, this will be a stopgap measure to ensure that that any backlog in trials will be addressed, Mr. Speaker. It's a good piece of legislation. We're glad to see it go to law amendments and hopefully passage this fall.
Thank you. The Honourable, the Liberal Leader.
Thank you, Mr. Speaker. As Justice Critic, it's a pleasure to rise and speak a few words on Bill number 89, the Provincial Court Act. Speaker, as has been pointed out by both the Minister and the House Leader for the NDP, this new legislation will allow the Attorney General to appoint a judge from another province to preside here in Nova Scotia if the Attorney General determines it to be appropriate. Mr. Speaker, under legislation, judges from outside Nova Scotia will have the same powers, duties, and daily rate of pay and benefits as judges enjoy in Nova Scotia. And Mr. Speaker, it also will allow that the judge from outside will hold office for as long as the Attorney General decides, so long as he or she is judge in their home province. Now, Speaker, what are the benefits of this change? Well, first of all, it's going to allow for a larger pool of judges, especially for French and possibly even other language trials in our province. Because the way it's worded, Mr. Speaker, this could possibly apply to more than just the English and French language, as we don't know what other services will be provided in the future, and I'd certainly welcome the opportunity to see even more languages being addressed in our province, especially when we talk about the need for immigration and welcoming people into our province from other countries. Mr. Speaker, overall, the benefit will be to make our justice system more accessible to all Nova Scotians. Speaker, one of the concerns which we do raise with this is that it's important to note that in the legislation, it not only provides for French-speaking judges, but it goes to say that wherever the Attorney General determines to be appropriate. And I'm curious as to whether we're going down a road here where suddenly the Attorney General may be looking to other provinces to bring in judges for certain matters here in Nova Scotia. I know that's been done in the past with judicial reviews, for example, but as far as an actual trial, I'm not sure if we've ever done that here as a province to bring in a judge from another jurisdiction. So I'm not sure if that's what's being contemplated in the bill or allowing that to be the case, and maybe the minister can address that when he closes debate on this. Mr. Speaker, clearly as an Acadian myself and as a French-speaking lawyer, there's been concern over the years about the ability to hold trials in French here in our province, and the big concern has been having actual judges who are able to hear trials in French. So, Speaker, while we're pleased to see that the minister is looking at means of making it more accessible for Acadians and French-speaking Nova Scotians to have their hearings heard in the French language, I think it's also important to remind the minister that when appointments are being considered for the bench, that the government should certainly undertake all efforts to try to put people on the bench who are French-speaking and who can clearly hold trials in the French language, so that rather than having to bring in judges from outside, we can have judges from here in Nova Scotia that can offer that service. Mr. Speaker, from the statistics we have, it's our understanding that we have 83 judges at all court levels in Nova Scotia and 8 supernumeraries to the Supreme Court. Of those, 3 Supreme Court justices and 2 provincial court justices actually preside in French right now. So needless to say, that's a very small percentage of the overall judges that we have here in our province. Speaker, we're also concerned that this legislation will only apply to provincial court, and that we would like to see whether the government's prepared to also extend these services to family court or even in Supreme Court, where trials are for more serious offenses. And we realize that these judges are appointed federally, but we'd certainly encourage the minister, in speaking to his federal counterparts, that when these judges are being appointed, that they do keep language as a consideration in determining what candidates are going to be named to the bench. Speaker, I want to, there's also the question as well as whether the government has actually approached the existing judges we have here in Nova Scotia to offer French language services to our justices. We are seeing that there's more French language courses being offered to our provincial civil servants. Federal civil servants have had that for quite some time. And I'm curious as to whether the minister, through Acadian Affairs, has actually offered the same service to our own judges. And maybe there are some who would be more than happy to take up that opportunity and to become bilingual judges as well. So that's something that we'd also encourage the minister to look into as well, and to take up with the members of the bench to see if there is an interest on that level as well. Speaker, I think it's essential that we recognize the efforts of l'Association des juristes d'expression française à Nouvelle-Écosse. This is a group of French-speaking lawyers which was formed now, I would say, at least, it was while I was in law school, so I would say it's been at least since 1994, 1995, when this group was formed. And since that time, it has been very active in meeting with government ministers, civil servants, and even with, in some cases, members of the opposition, to push for better services in our court system for both Acadians and French-speaking Nova Scotians. Mr. Speaker, I can tell you, having had the opportunity to attend court on a number of occasions, when you bring someone whose native language is French or Acadian, who's not overly comfortable with the English language, and you put them in a court setting, which to start off with is puts a considerable amount of pressure on them, and in many ways makes them very anxious and nervous. It makes it extremely difficult for them to understand the instructions that are coming from the judge or the questions being asked when it's being done so solely in English and legal terms are being used. It makes it extremely difficult, Mr. Speaker, and it's not only a matter of looking at judges that can be able to offer trials in French. We also have to look at our judicial system as well. And the current Minister of Justice would be familiar with this, and especially his predecessor in Justice, who I want to commend, did start addressing this matter. But, for example, Mr. Speaker, sheriffs, which are such an essential part of our justice system, for many years in Nova Scotia, we did not have any emphasis on having bilingual sheriffs. And I can tell you, anyone who's attended court, especially on plea dates, or even for minor matters, it is often the sheriffs that are called upon after the judge has made a ruling to actually explain to the accused what the ruling is. And in many ways, Mr. Speaker, the sheriff is the essential person outside of the judge, because the judge makes the decision, but it's the sheriff that's often called upon, he or she, to explain what that ruling actually was. For example, if it's a speeding ticket, it's to explain, here's how long you have to pay, here's how much you have to pay, here's where you go and pay, and here's what happens if you don't pay, for example. And in many cases, if you had sheriffs who could speak French, it would certainly be a great service to French-speaking Nova Scotians who would better understand exactly what it is the judge has said. Because even if you understand English, I can tell you, Mr. Speaker, having been in court, many times the sheriffs are asked to explain even when the judge gave his ruling in English because they simply don't understand what it was exactly that the judge has said. So I know there was an effort by the previous minister to try to identify certain areas of our province where any new sheriffs being hired would be bilingual. I do hope that the current minister will encourage that even more, because sheriffs are an essential part of our justice system, and especially our court system, and I'm sure that the minister is well aware of that. And so I know in my area, and now in the Port Hawkesbury area, we do have a bilingual sheriff, but I do know, for example, communities such as Pumket in the Antigonish area are still looking for that service, in many other areas in our province. And let me again reiterate what the approach has been by the French lawyers. They have never suggested that anyone lose their employment. Instead, what they have said is when new positions come up or when there are openings after retirements, use that opportunity to fill it with a bilingual person if the service warrants it in that area. So I believe it's been a very proactive approach, yet a reasonable approach, and one that can easily be adopted by the government. And I do look forward to seeing more job postings in the Department of Justice which do have bilingualism as a requirement, not just as a preference for specific areas of our province. So again, Mr. Speaker, I want to commend the French-speaking Lawyers Association. I'm sure this will be good news for them. And it's, again, I think a reflection of some of the lobbying efforts that they have undertaken here in our province. Monsieur le Président, permettez-moi juste quelques minutes pour dire quelques mots sur le projet de loi 89 qui fait les changements au système de cours ici à la province de Nouvelle-Écosse. Monsieur le Président, comme vous le savez, la communauté acadienne, la communauté française, pendant plusieurs années, est en train d'encourager le gouvernement de faire certain qu'il y a des meilleurs services offerts en français à nos systèmes de cours ici à la province. Comme je l'ai dit en anglais, au moment, nous avons 83 juges à tous les niveaux des cours ici à la province de Nouvelle-Écosse. De ce numéro-là, seulement 3 juges de la Cour suprême et 2 juges de la Cour provinciale sont préparés maintenant à entendre des processus en français, entièrement en français. Alors, c'est clair que les changements qui sont proposés ici aujourd'hui, Monsieur le Président, permettraient au Attorney General de vouloir aller nommer un juge hors de la province si nécessaire pour avoir un processus dans la langue française ici en Nouvelle-Écosse. Comme je l'ai dit plus tôt, j'encourage le ministre, quand ils sont en train de nommer des juges ici à la province, qu'ils se tiennent en idée d'avoir des juges qui vont être nommés, qui peuvent parler français, comprendre le français et avoir des processus entièrement en français. Monsieur le Président, je pense que c'est essentiel à notre système de gouvernement, notre système de justice, que nous sommes préparés à offrir les services à la communauté acadienne, à la communauté francophone dans leur langue. Et j'encourage le ministre de Justice d'offrir même autres services, par exemple les sheriffs qu'on utilise dans notre système de justice. C'est souvent eux qui sont demandés à donner les explications une fois que le juge a fait la décision. Et souvent, si les personnes ne sont pas confortables dans la langue anglaise, ils vont avoir beaucoup de misère. Alors, je sais qu'il y a eu des démarches qui ont été entreprises sur cette question. Et puis, j'encourage que le ministre va tienne ça en idée dans le futur. Alors, Monsieur le Président, je veux prendre cette occasion pour féliciter l'Association des juristes d'expression française de Nouvelle-Écosse pour les années qu'ils ont travaillé avec le gouvernement, avec les fonctionnaires, avec le gouvernement fédéral, les langues officielles et avec les partis d'opposition pour encourager meilleurs services pour les gens en Nouvelle-Écosse au système de justice dans notre province, dans la langue française. Et je suis content du travail et je les encourage de continuer avec ça. Speaker, let me finish by saying it is great to see that the government is moving on trying to provide better services to the Acadian and French population in Nova Scotia in our court system. And I believe that when we look at our democracy, the operation of our court system is an essential matter that we want to make sure that Nova Scotians clearly see that their rights are being respected, especially their language rights. Mr. Speaker, I would be remiss if I did not take the opportunity again to remind all members of this House that it is great to be offering those services to our court system, but I believe in our democratic state, I believe one of the other places where Nova Scotians look for leadership and to see where democracy is working at its best, it is here in this chamber. And as I speak today, Mr. Speaker, November 14, 2006, it saddens me to again have to remind the House that we do not have translation services here in this Assembly. Now, Mr. Speaker, I do want to take this opportunity to commend the Chair of the Law Amendments Committee, who is also the Minister of Justice, along with the support of the Minister of Acadian Affairs. We had translation services at the Law Amendments Committee, I believe possibly for the first time we've ever had in this province. The issue there was the supplementary funding and the concerns that were coming from the Conseil scolaire acadien provincial and interested parties. Speaker, I thought that worked extremely well at Law Amendments. I believe all members there, the Chair included, was impressed with the service and how well it worked. And I believe it's time that we as members in this chamber look at having those same services here. I believe that the funding would not be a major problem for us, but if we're going to have Nova Scotians of French and Acadian background look to our elected system and our democratic system as respecting their rights, there's no better place to start that but here in the House of Assembly. We've shown it could be done at the Law Amendments Committee. It certainly can be done in this Assembly as well. And Mr. Speaker, I do hope that the Minister of Acadian Affairs will continue to push for that matter, and I do hope that even the Premier of the province will clearly indicate his desire to see that translation services be provided in this House of Assembly in the very near future. So with that, Mr. Speaker, I do look forward to Bill 89 moving to second reading, and possibly the Minister of Justice may want to address some of the comments that I raised during my remarks as well. But I do commend the Minister for bringing this forward and look forward to the comments that will come from the Law Amendments Committee. Thank you, Mr. Speaker.
Merci. L'honorable ministre responsable aux affaires acadiennes.
Merci beaucoup, Monsieur le Président. J'aimerais peut-être parler pour une couple de minutes. I'd like to speak for just a couple of minutes on Bill 60 or Bill 89. Mr. Speaker, I think this has been a tremendous amount of work on behalf of the Department of Justice, and I want to thank the Minister for bringing this bill forward on behalf of citizens of Nova Scotia, especially the Acadian communities in which we all represent. From many conversations, de beaucoup de discussions qu'on a eues dernièrement avec la JEVNI ou l'Association des juristes d'expression francophone ou français de la Nouvelle-Écosse, moi je pense que ça se donnait beaucoup de l'air à cette idée de vraiment d'avoir l'opportunité d'avoir des judiciaires en cours ici en Nouvelle-Écosse de d'autres régions, notamment de venir de Nouveau-Brunswick ou d'autres endroits du pays du Canada. Very much to bring other judges from other areas in the country in order to hear court cases in other languages, including French, which of course really helps out the Acadian community in which most of us represent. Mr. Speaker, I think that through a larger committee that we have through the Office of Acadian Affairs, which we're working with 17 different ministries and organizations within government to bring baseline services available in two languages, has been a tremendous success as we roll towards the issue of Francophone services or French services in all corners of this province. So again, I commend the Minister responsible, the Minister of Justice, for bringing this very important bill forward, and I look forward to bringing this good news to the Association, the AJEVNI, or the Acadian Francophone Jurists during their AGM, which I think is being held on Saturday, I believe at 5 p.m. In the Speaker's own writing. So we look forward to bringing this news to them, to see what their thoughts are I think there is an opportunity at a future date to maybe expand on some of these services in all departments across government. And Mr. Speaker, I do look forward to furthering discussion on French services for all Nova Scotians. Thank you.
Merci. I'll recognize the Honourable Minister of Justice to close debate on Bill number 89.
Thank you, Mr. Speaker, and thank the honourable members opposite for their comments and suggestions and concerns, I guess, around Bill number 89. The honourable member, the honourable leader of the Liberal Party raised the issue about where it would be appropriate in appointing of a judge. I want to assure the honourable member it would only be circumstances where, in consultation with the chief judge, it would be determined appropriate. Obviously, the language issue is one. Other situations may be around issues of conflict of interest, which may be required to appoint an outside judge. But, Mr. Speaker, I believe that this has the support of all Nova Scotians, and I believe, certainly from what I've heard here today, I believe that the members support this, and I look forward to this going to law amendments for further debate. And, Mr. Speaker, with that, I move second reading of Bill number 89, Provincial Court Act.
Thank you. The motion before the House is for second reading on Bill number 89. Is the House ready for the question? All those in favour of the motion, please say aye. Aye. Those against, motion carried.
Bill 89, entitled an act to amend Chapter 238 of the Revised Statutes 1989, the Provincial Court Act.
Order that this bill be referred to the Committee on Law Amendments. The Honourable the Deputy Government House Leader.
Thank you, Mr. Speaker. Mr. Speaker, I'd like to call forth Bill number 92, Assessment Act.
Public bills for second reading. Bill number 92, the Assessment Act. The Honourable the Minister of Service, Nova Scotia and Municipal Relations.
Thank you, Speaker. I'm pleased to rise to be speaking on the amendments to the Assessment Act, Bill number 92, that would extend the CAP assessment program again. Mr. Speaker, the CAP assessment program was introduced in 2005, and it was designed to help protect property owners from sudden and dramatic increases in property assessments by placing a limit or a cap on the amount of taxable assessment increase on eligible properties. Mr. Speaker, in the current legislation, it is unclear whether the CAP assessment program extends beyond the 2007-2008 fiscal year. And what this amendment does is to remove that uncertainty, and it will indeed extend the program. Now, the extension of this program will enable our government to continue to provide some relief to those Nova Scotians who, through no fault of their own, have been affected or would be affected by significant increases in property taxes. Mr. Speaker, homeowners want protection from dramatic increases in property taxes, and this legislation will help provide some of that protection. Now, to be eligible for the CAP, a property must be owned by a Nova Scotia resident and meet certain other eligibility criteria. Mr. Speaker, to date, more than 70,000 Nova Scotians have applied for the CAP. And our government will continue the CAP on sudden property assessment hikes and consider further steps in consultation with the Union of Nova Scotia Municipalities to help Nova Scotians deal with higher property taxes. Mr. Speaker, passing these amendments will be good for Nova Scotia property owners. And Mr. Speaker, I now move second reading of Bill number 92, Amendment to the Assessment Act.
Thank you. The Honourable Member for Waverley, Fall River, Beaverbank.
Thank you, Mr. Speaker. I do agree with the minister that that homeowners need protection. I would like to add, certainly since I've been an MLA, one of the areas that I'm receiving increased phone calls about is due to property assessments. I live in a riding, Mr. Speaker, that's a very it's an aging riding, and as a result of that, I often hear too often. I get at least 2 or 3 phone calls a month from residents within the riding concerning their assessments and concerning the real threat, Mr. Speaker, of them having or being pushed out of their family residence, their family dwelling. They're being on, because they're on a fixed income, and because of the cap hasn't benefited them enough, they feel that with the increased assessments, their fixed income, they can't keep pace. Something that's missing with the cap is that it would seem from where I sit that the cap would better serve for protections for more Nova Scotians if the cap was adjusted so that more Nova Scotians could qualify under the assessment cap. I think government has to be more proactive in their mindset when it comes to assessment caps and think about incomes of property owners. And therefore, it would make some sense to me, Mr. Speaker, that the cap needs to be adjusted and maybe tied to consumer price index. This bill is also dealing with the cap being extended to the 2008, 2009, and subsequent municipal taxation years. And hopefully in the, it would have been, again, to use the term I've already used, if we're going to be more proactive about this, it's too bad that the cap wasn't just automatic. So there's two things I think that I have concern with, and one is the not enough Nova Scotians being available under the existing cap, and again, that it's not automatic. Thank you, Mr. Speaker.
Thank you. The honourable member for Halifax, Clayton Park.
Thank you very much, Mr. Speaker, and it gives me pleasure to rise today and just say a few words on this bill number 92, which are the amendments to the Assessment Act. Mr. Speaker, I've spoken in the past when this act was first introduced several years ago. I spoke against it at that time and said that it was wrong-headed and that it was not something that we felt was going to address the root cause or the real problems. And I feel that the government had a commitment to come back in 3 years' time and let us know what the review of it was and how it was going. And they have not done so, Mr. Speaker. And this act that's before us today allows a continuation of the cap as it exists, no changes at all, no review being done, and it's simply going to come back and allow the government to roll it over year by year and continue to do it in the absence of any further review. And I think that is, again, the wrong thing to do. When the cap was introduced, I was certainly prepared to see whether or not it would work effectively. What we understood, and I sat on law amendments at the time, and I heard from individuals who came and spoke very sincerely about the difficulty they were having or their family members were having in maintaining their homes. One woman in particular spoke about her mother who had an older home in Chester and had lived there all her life and was finding the assessments were rising to a point where she would be driven from her home. Those kind of questions were really compelling, and I know they exist in the Premier's own riding, in a lot of areas that particularly are coastal, the deck area, areas that are attractive to people who come on a seasonal basis to live. And we know that there's been a real problem across the province in rising assessments, and I mean a problem in terms of the individual's ability to pay. And that comes back to the mechanism we use to set our assessments, Mr. Speaker. Really, the system that's in place, what I'm told by the department and by others who work in it, is that the market system is a very dependable way to assess the value of properties, and that the formula used is a good formula, and that other jurisdictions come here to use and see how we do these annual assessments. That may be, but there is a there's two variables to the formula that set our individual taxes. One is the assessment, which is based on market value. The second is the individual municipality's rate that they apply to that assessment. So consumers, or homeowners in this case, have been left with these two floating variables and no one really to hold accountable as their costs go up and up. And when they call their MLA, they're told that the rate can be adjusted by the municipality, which is true. The municipality often has hidden behind the fact that the assessments have risen so dramatically because of the market value of the properties. So people who own homes and condominiums have not been happy because there's not one level of government that's solely responsible, and because their rates keep rising and so do their taxes. And they're having a hard time staying in their homes. But if the cap was intended to help people who are low income to maintain their homes, Mr. Speaker, it hasn't been effective. I think it has helped to shelter other people from high taxes. It may have helped people who already had bought the expensive homes or built new homes that were driving up the assessments around them. It may have helped them significantly, Mr. Speaker, but my concern is that it hasn't done a great deal to help low-income Nova Scotians who were struggling to hang on to their home ownership. And I think we have something like about a 70% home ownership in this province, which is a pretty high rate. I know in my own riding, which has so many apartments, it's very low. But overall in the province, we have a high rate of home ownership, and that means a lot of the low-income people that we've heard of today. I know one of my other colleagues today had mentioned that 50% of Nova Scotians earn less than $25,000 a year. Well, it's very good to know that a lot of them own homes. If 70% of our people are living in their own homes, then many low-income people own the home that they're living in. So we want to help them and shelter them from great increases in taxes. And this cap hasn't really done that. I mean, I would have welcomed a review if the department wanted to do the review and come back and show us who's been helped by the cap and how many people and how effective it's been. I would welcome that review. And in fact, I've had correspondence as well, Mr. Speaker, from the UNSM indicating that they are very unhappy to see this act come forward, that they expected a review themselves, and they had been promised a role in the review, that as the organization representing all of the municipalities in this province, the 55 different municipalities, they would have a voice in how this was going to go forward. And they have been denied that voice as well by this act coming forward for second reading today, as it's doing. So my concern is twofold. One, that we haven't found the way to protect our low-income Nova Scotians as we really intended. The other is we haven't got information on how well this has worked in the last few years. As it was being introduced, there were certainly concerns, Mr. Speaker, about the fact that individuals had to take a step themselves and ask to be assessed for this CAP program. A lot of us would have received, and I did at my home as well in Clayton Park, I received the form that said you may need to send this in. You may be in an area where the rates or the assessments are rising so quickly that you might qualify. I have to tell you, Mr. Speaker, that in last year's assessment, mine rose 9.9%. And I know other people who find that a little bit suspicious. I've even talked to municipal councillors who feel there's almost a conspiracy about rates going up 9%, yes. And they say people are frightened to apply for the rebate because they think then that might push theirs up higher. So the fact that it's not an automatic thing, that if your assessment rises over 10%, you automatically would get that additional amount over 10% would be sheltered from tax. You know, it hasn't worked that way. It hasn't been an automatic. The department has required individuals to take the step to understand the forms, to send them in, to ask for this sheltering. And, you know, I would really like to know from the province who has done that, how many, where do they live, how successful has it been? And again, the largest outcry, Mr. Speaker, had come from the counties of Lunenburg, Chester, along our South Shore particularly, a big outcry about assessments, and I know that led to the government looking for an answer at the time, several years ago, in the wake of the 2003 election, wanting to respond to Nova Scotians who had a problem. But having adopted this cap, I don't think that they have even wanted to go back and review the problem again or really address it, you know, in a significant way. And the fact is, here we see a piece of legislation that is saying, let us just continue to do what we're doing. Whether or not it works, whether or not we have any evidence that it works, we can tell Nova Scotians we're doing something, so it's something to hide behind. It looks like there's been some action taken. But really, in fact, Mr. Speaker, nothing is happening here. And I think that it's such a difficult problem that it would seem to me the province just doesn't want to open that can of worms again and try and deal with how do we protect low-income Nova Scotians and let them stay in their homes? How can we protect them from rising municipal taxes? You know, and I think that UNSM would want to work with the province. One of the programs that was in place on HRM, and still is, I became aware of it when I was a councillor, and I know there are other former Halifax regional councillors that sit in this legislature. The Halifax Regional Council was not unusual in having a program that would protect low-income Nova Scotians or residents. And people could apply if their income was below a certain threshold, and I think it's gone up as high as $27,000. It was quite a high rate, really. It was not extremely low. And they had said people whose income falls at that level or below could apply for a sheltering, and I believe it's a deferral of tax. So at some point down the road, the municipality would recoup that tax. But they would recoup it at the sale of the home or if the home was changing ownership, Mr. Speaker. And so even the municipalities have recognized the need to help their residents. You know, they are not, the councillors on all of those municipalities across the province are not unlike we are here. They want to respond to Nova Scotians who are in need. And they want to do the best that they can for those people that they know have a genuine requirement. They have a need to keep a roof over their head and be looked after. So, Mr. Speaker, for that reason, I feel that if the government would sit down with UNSM and with those municipalities, they would find that there may be an answer among all those people. They may have the answer. And I do believe that, and I'd spoken at the time 3 years ago when this went through, that the municipalities should be asked to all have a program like that. I don't know if each of them do, but I think through UNSM they could introduce a program where all of them recognize the need to shelter people in low income, people with low incomes or seniors with fixed incomes, so that they would not have to worry about the pressure and impact of these rising assessments. Because as you know, Mr. Speaker, I don't think I need to quote figures on how quickly some areas have risen, but people have seen a doubling and more of their taxes over a short period of time in certain hot spots. And again, in District 10, which is Clayton Park West, I think it was a year ago, the increase was an average of 18%. And that, again, is an awfully big jump in a single year for an average for a district. I'm told, Mr. Speaker, that gets pushed up somewhat by new buildings as well. So they're not all existing ones, but because the assessment role has increased that much, new building actually does impact that. So it may have been partly fueled by that. But I've had the angry phone calls, as I'm sure other members of this House have, from people who are really, even people with good jobs and who are working, who really feel that it's offensive to see how much these increases are in their tax bill. Now, again, I go back to the fact, Mr. Speaker, that the tax bill is in the hands of the municipal councillor. They can set the rate. But because the assessments is part of that formula, we do bear some responsibility here in this House to see that if there are mechanisms used in other jurisdictions, if there's a better way out there, that we should be looking for it. And I don't think it's sufficient to come up with an act as we have today, which says, let's just keep doing it the way we've been doing it the last few years. And let's forget about the commitment to report back to the House with some review of how this has worked. And again, Mr. Speaker, just to bring you back to the original act, it was patterned on a piece of legislation in California, which again was addressing coastal properties that had gone up so much in their rates. And at that time, Mr. Speaker, in California, they set the annual increase, or the amount that would be capped, at something like 3%. Here in Nova Scotia, under regulations, the cabinet has set it at 10%. So an individual homeowner, even with this cap system in place, is subject to as much as 10% increase every year in their assessment, which means that their taxes could go up. If the rates aren't changed by municipalities, their taxes could go up 10%. And we're only sheltering the amount that might be above 10%, saying that that additional lift is exceptional. Well, Mr. Speaker, I would say that a 10% lift is exceptional. And that really, if we were serious about protecting people in their homes, that we would look at a lower rate. Or we would do it on some kind of a means test like the municipalities do, really saying that this isn't intended for everybody. It's not intended for people who don't need our help. It's intended for the people who really cannot afford to stay in their homes, who are living on fixed incomes. And so, Mr. Speaker, in essence, I feel that this act should not be moving forward in the legislature, because I don't think that the government has done what it had promised to do, which was to provide a review of the existing program first. And in the absence of that review, as I say, I'm going to wait and see what we hear at at law amendments. I hope that we will hear from Nova Scotians. If they feel this has been successful, then I hope we hear from them. And I would like to hear from the minister if there are intentions to do a formal review of this program. But in the meantime, we're certainly waiting for it to go through law amendments, and we will then decide what the next step is. But thank you very much, Mr. Speaker.
Thank you. The honourable member for Halifax-Citadel.
Thank you, Mr. Speaker. Mr. Speaker, I'm happy to speak here today on this on Bill 92, which extends the cap on home assessments. I think certainly in Halifax-Citadel, that was one of the biggest issues in the last campaign, and since then, we've got numerous complaints about the sudden dramatic increase in home assessments, and essentially people being taxed out of their homes. In particular, I was surprised to see how many people who were living in homes that on the surface seemed to be relatively prosperous, but were living under appalling conditions, particularly, Mr. Speaker, seniors in Halifax-Citadel. I know the perception outside the area is that this is probably one of the wealthiest parts of the province. But in reality, especially for seniors, they're land rich, but they're cash poor. They're not able to maintain their homes. Many seniors are living in homes where the heating has been turned down, parts of the house have been shut off, and they really are living not on the poverty line, but they're effectively living in poverty if they're cutting essential services in order to make ends meet. And also we met many young families that have inherited their homes who really are struggling with raising families and are just not able to deal with these sudden dramatic increases. So we really welcome the extension of the cap, even though the cap is 10%, which in and of itself is quite a challenge for most people. I think in general, the market-driven process is just not working. Some people are facing increases of 300 to 400% increase in their assessment value, and they don't seem to have any understanding of why that happens, or what bearing that has on the level of services that they get, especially if they're looking around and seeing other levels of society, particularly politicians and other groups, having the system respond to their needs in terms of income, where they themselves find their costs rising, but their revenues are fixed in many ways. So a fair tax system has to get beyond the market-driven process, although the market has to play a significant role in setting that price. In particular, we would like to see assessments set to the Consumer Price Index, which is a fairer way of setting rates. It's linked to a basket of commodities. It tells you what's generally happening in society, the inflation rate, and it tells you something about ability to pay, especially for those whose incomes rise, at least in some kind of sync with the Consumer Price Index. We also think that they should be linked somehow to means. Earlier this week, or last week, the member from Richmond introduced a bill saying that people who have hit catastrophic conditions, health conditions, that those people should be allowed to dip into their pension funds. And we opposed it, Mr. Speaker, in large part because we think that was an extraordinary situation. But here we have a case where people in difficult situations, especially relating to health and ability and age, and just ordinary working conditions, we can say to them, let's look at your means, let's look at your ability to pay, let's look at what this assessment increase and this area rate increase is going to do to your living conditions, and we should use means as a way of determining that price. There should be some link to the level of services received. Many people in my constituency feel that their assessment rates and their area rates rise so dramatically, and they see no increase. They see no reason for that. They complain about snow removal. They complain about user fees, that recreational fees are being lost. And they say, how is it that we can have these tremendous increases in our assessment and in our taxes when we're not seeing any connection to the service? So there should be some connection to the service. There should be some connection to means. There should be some connection to the consumer price index. And perhaps sometime down the road, Mr. Speaker, we'll be able to look to something more akin to a more progressive income tax system or a progressive assessment system that looks at overall income as a way of determining the assessments that people would pay. In particular, I'd like to speak to really one set of issues, but under the same general heading. There's a question of unfair funding for services at the municipal level. That the service exchange itself is unfair, that the province essentially has the authority to do a great deal with the municipalities, but it doesn't have the responsibility for bearing the brunt of those decisions. That the downloading of responsibilities to municipalities drives the frustration that's felt on the doorsteps. Earlier this week, we passed on second reading a transfer of $500,000 in the supplementary funding to the French language school boards. We supported that. It's the right decision in principle, but at the same time, that's a loss of $500,000 from one board, and it's transferred to the other. And so we need to know what we're going to do with that shortfall of $500,000. We see the issue of supplementary funding, where one school board has supplementary funding, and those students get art and music and sports, and others don't. There's a principle of equity that we're trying to establish in municipal taxation and municipal services that has to be addressed in our assessment system, and it has to be addressed in the area rate. A school that's being built in my constituency, Mr. Speaker, Citadel High School, is not going to have an auditorium. We've decided that art and music and all of these community events are not important enough. It's not going to have an auditorium because we're not, it's not considered to be a financial necessity. Yet at the same time, we say to the school boards that they should have art and music and gym, and all of these programs are important, and they're all connected to assessments. This week, we're talking about policing and adding police officers and video cameras. The municipalities will take on this burden as well. The other municipalities are talking about equalization and equity in taxation across municipalities and providing equal access to service. There are a whole range of issues at the municipal level. We have this inequity between unfair funding and inadequate service exchange, in exchange for those services, and those issues too need to be addressed because they're connected to assessments. We'd also like to say something about the appeals process itself. Yes, we do need a cap, and we can argue about whether 10% is low enough. We've talked earlier about the consumer price index. But yes, if you qualify for the cap, then it should be automatic. Why drag people through the bureaucratic process to fill out forms? You know, if they qualify, why not just give it to them and save them the burden? They will be paying 10% of the tax anyway. We don't need to impose an administrative burden on them. And the forms should be easier to fill out. They should be easy to understand. Most seniors have no clue about what their rights are in this process. Most people are just not familiar with the intricacies of the Assessment Act. And people should also get timely information as to when their rates are going to go up. In the last round, they got the information after the appeal time had run out, after the deadline for appeals had run out. That hardly constitutes a fair process, Mr. Speaker. And so we see two other things this week that are going on simultaneously that point to the need for a review of this whole assessment process. Later today and perhaps tomorrow, we're going to be looking at the Assessment Act and the transfer of assessment services. There's a great deal of debate there about how these assessments are set and what level they should be done at and how timely and how responsive they are. And yet there's no connection to the general principles of assessment. There's no connection to service exchange. The HRM is also engaging at this moment in a tax review and the setting up its area rates, and they have a committee that will be going around. Everywhere we look, there are these concerns about assessments in terms of the overall increase in assessments, the process of assessments, what level of government is doing what. And so this is a great opportunity for a formal review of our assessment situation and the relationship to the services you get in return. So I think we should have a closer look at this bill. It is an extension for another year and perhaps more, but we should look at these other larger issues, whether or not assessment should be linked to the consumer price index, whether or not it should be linked to one's means and ability to pay for it, whether or not they should be linked to services received, and whether or not we can establish it along the same lines of a progressive income tax system. And of course, the cap process itself needs to be reviewed in terms of making it automatic to those who qualify and making the process less cumbersome. And I'd like, Mr. Speaker, to see this government move to a more thorough assessment of this situation in a dialogue, and open up a dialogue with the UNSM and the HRM and other municipalities across the country, across the province, so that we can come up with a fair way of setting assessments and establishing who gets what, when, and how in this process. Thank you, Mr. Speaker.
Thank you. The honourable member for Halifax Fairview.
Thank you, Mr. Speaker. I wanted to take this opportunity to put on the record a few thoughts from my own constituency, because the property assessment program and the CAP program in particular have been a source of some consternation in the area that I represent. Market value as a principle works reasonably well as a way of deciding on municipal services until you have a rapidly rising market, or to be more precise, where you have a rapidly rising market in some places but not in others, which is exactly, of course, the situation we've had in Nova Scotia for the past number of years. And I do want to pay particular tribute to my colleague from Timberley Prospect, who quite a number of years ago now, it must be 3 or 4 or 5 years ago, was the first one to take this issue and put it on everybody's radar screen. And the issue that he brought to this House had to do with rapidly rising assessments for waterfront properties in particular, of which he has quite a number in his own constituency. And he had noticed how the assessments were rising very rapidly for the waterfront properties, very much more rapidly than other properties. And so what that did was it underlined the fundamental issues with using market value as a means of deciding on everybody's share of municipal services. So we've had this issue for a number of years where some areas of the province, market values are rising very fast, other areas of the province are rising very slowly, and certainly it's happened in the constituency of my colleague from Halifax Citadel. It's happened in mine, Halifax Fairview. I know it's happened next door in Halifax Clayton Park. In a number of places which are growing fast, this has become a real issue. And so what we look for from the provincial government, I think, is some kind of a comprehensive, well-thought-out solution. And that, of course, is exactly what is missing. The CAP program is, and always was, an interim solution. It's a way of dealing with the most egregious cases until the policy is fully thought out and is changed to reflect the new circumstances we find ourselves in. So, to a certain extent, it has to be disappointing for all of those property owners in Nova Scotia whose assessments have been rising to see that the government's solution again this year is simply to extend the CAP program. Now, in and of itself, the CAP program is fine. We've always supported the idea behind it, and we support it again this year. But the government, surely, they have to have more to offer than that, than simply extending this very temporary solution for yet one more year. I want to talk very briefly about the problems that I've seen in my constituency. I guess first and foremost is the problem of the lack of knowledge among property owners of the program and how it works. Now, the government does have an advertising campaign, but I wonder sometimes how often the government evaluates the effectiveness of the advertising campaigns that it undertakes. Is it really reaching people? How many people know about the program as a result of the advertising program? Because my experience as a representative for Halifax Fairview is that whatever information the government's distributing is not getting to nearly enough people. And that's tied into the problem raised by the application process. This is not an automatic cap on one's property assessment. It's something for which one has to apply. And you would think the government would have learned by now that any process that requires an application brings in all kinds of issues that are quite apart from the public policy program for which people are applying. There is a serious problem in Nova Scotia with literacy. And it is simply naive to believe that most adult Nova Scotians know how to fill out a form, especially dealing with something relatively technical like property assessment. Now, I heard the minister stand up the other day, or he said it somewhere, and I can't remember if it was inside or outside the House, and he said he applied for the CAP program for his home, and he found it to be a fairly user-friendly form. Well, I'm not surprised, Mr. Speaker. He's a PhD. He's a very well-educated person. The people that I deal with in my constituency are not PhDs. They are not used to dealing, well, the PhDs in my constituency don't need my help. Not to say I don't have PhDs. They're not the ones who are calling me for help. The ones who are calling me for help tend to be the seniors who went through school when it was okay to leave after grade 4 to go into the workforce. You know, the people, the blue-collar workers who got through life without ever really having to deal with a lot of forms, a lot of complicated processes. And, you know, I have to disagree with the minister. It is not that user-friendly a form if you're not very well educated, or if you're not very literate, or if your eyesight's not as good as it used to be. All these things that we see among the population most in need. And I know all this, Mr. Speaker, because this year I decided to help the government, which, you know, we on this side like to do. It's something that we take pride in as part of our opposition. I decided to help the government by sending out my own leaflet to every single homeowner in my constituency, telling them about the CAP program. Now, the government relies on newspaper ads. They rely, I'm not sure what other media they use, but the one thing they don't do is send a leaflet to every single home. And again, even if they did, there's a certain number of people who wouldn't be able to read them or understand them. And I sent a leaflet, and the response was wonderful. The response was overwhelmingly positive. Thank you, people would say, for telling us about this program. And these were people often, you know, very reasonably well-educated, working people. You realize in circumstances like this how few people actually read a newspaper. You know, there's lots of busy working people who simply never open a newspaper. And so if the only place the government puts ads is the newspaper, well, those people aren't going to see them. But I put a leaflet in every single mailbox in my constituency saying, here's the program, the deadline's coming up, here's how it works, here's how it benefits you. I really encourage you to apply. And what that did was engendered quite a number of calls from people asking me to come out and help them fill out the form, which I did. So I sat at people's kitchen tables, and I was able to see how they were reacting to the form. And I have to tell you, Mr. Speaker, it's not a simple form. I have to disagree with the minister on that. It's not a simple form. For a very well-educated person, used to dealing with government, used to filling out forms for this, that, and the other thing, it's probably pretty straightforward. But that's not the typical user. Not at all. I think in particular of one very elderly lady living alone, and I sat at her kitchen table and helped her fill out the form, and without the assistance of me or somebody like me, she would have been utterly unable to apply for the CAP program. And I think that often the government doesn't take this into account. And that's why what we in the NDP have been saying from the time this program was started is it should be automatic. This should not be an application-based program, because the people who get disqualified are the people who have difficulty filling out the form. The minister filled out the form for his house, and Mr. Speaker, I filled out the form for my house. My house is under the CAP. I benefited from the CAP program, but we're not the people who are likely to lose out with the difference between an automatic program and an application program. because we do that. We're used to doing that. We know how to do it. I am afraid that there are tens of thousands of Nova Scotia homeowners who are losing out because of the difference between an automatic program and an application program. Why does it have to be done by application? For the life of me, I still do not understand. And ever since this program started, we've been saying to the government, make it automatic. Your computer system tells you who's eligible. It tells you whose assessment has gone up by more than 10%. Why don't you just make it automatic? And then if somebody wants to opt out of the program, well, heck, let them fill out an application form and opt out of the program. Although I can't imagine why anybody would want to opt out. But opting in excludes often the very people who most need the program. That's the problem. I don't understand. We've never understood why it has to be an application-based program. The government has never offered us the least convincing reason why it needs to be an application-based program. It should be automatic, and we say that again today as we have a bill in front of the House extending the program for another year. Another problem with the program, Mr. Speaker, is that you apply for it based on your provisional assessment, your interim assessment. But the actual assessment is based on your final assessment. But if there's a change between the provisional assessment and the final assessment, well, Mr. Speaker, you're just out of luck. Now, many people receive an assessment increase on their provisional assessment of 3, 4, 5%, and they would say to themselves, well, and these are the people, Mr. Speaker, who are even aware of the CAP program, which is a decided minority of the population. They would say, well, you know, the cap's at 10%, so there's no point in my applying. But then when they get their final assessment, it might have gone up by 15 or 20%. We even had a case earlier this year, Mr. Speaker, of a woman whose provisional assessment went up 3% and her final assessment went up 390%. That was a waterfront property. And that's a problem because she hadn't applied for the CAP program by the time she got her final assessment to realize that she should have. It was too late. The deadline had already passed. And that's another aspect of this program we have never understood, is that the deadline for applying is before the date you get your final assessment. We've never understood why that has to be that way. It's almost Kafkaesque, Mr. Speaker, in the way you have to apply for a program before you know whether you qualify for it or not. That doesn't make an awful lot of sense, Mr. Speaker, and it's the only program I could think of where that's the case. And if you explain to people, they say, what? How could that be? That doesn't make any sense. You have to apply for it before you know whether you qualify. Just saying it sounds absurd. It is absurd. It needs to change. And I wanted to underline those problems today, Mr. Speaker, because despite our repeated requests to the government to fix the CAP program so that it works better, to take into account low literacy levels, to take into account the very low level of knowledge among the population of the CAP program, to take into account the fact that it ought to be an automatic process, to take into account the fact that people need to have an opportunity to apply for the program when they get their final assessment, not just their provisional assessment. Those are the kind of things we would like to see the government do. And not to mention that we'd like to see the government come forward with a final fix. Either they're going to stick with market-based and say we're going to stick with it for better, for worse, or we have another plan and here it is. But none of those things is happening. The only thing before us is an extension of the same flawed program for another year. Meanwhile, at Halifax City Hall, they are at least looking at the issue. They have recognized that market-based assessments aren't working well in a rapidly rising market, and they have struck a committee to explore alternatives. And that's a good thing, but I have to ask, Mr. Speaker, why is the Halifax Regional Municipality leading this initiative? This is an initiative that should be led by the provincial government because it is a provincial issue. So, with that, Mr. Speaker, I will conclude. Of course, we support the bill. We support extending the CAP program for another year, but there are some significant flaws in the program, and it is disappointing to us to see that, again, for another year, the government has failed to address those flaws. Thank you.
I recognize the Honourable Minister of Human Resources will be closed debate on Bill number 92. The Honourable Minister of Human Resources.
Thank you, Mr. Speaker. And Mr. Speaker, just before I conclude debate, I did want to thank the members opposite for their useful suggestions, and wanted to re-emphasize the importance of passing this particular piece of legislation at this point, because if this House is interested in affording the protection of cap to the citizens of Nova Scotia on their property tax, it has to be done at this juncture in time. As well, I want to point out to members of the House that certainly the Minister and his department have assured me that the other partner and the beneficiary of property assessments, the 55 municipalities from the Union of Nova Scotia Municipalities, require a year's notice on changes, and they're the second party that government has to come to an agreement to, rather than arbitrarily make decisions on their behalf. And the minister has assured me that discussions and talks continue with the Union of Nova Scotia Municipalities in that regard to the cap, and if there's better ways to afford it to all Nova Scotians. So with those few remarks, I would like to move closure on Bill 92, the Assessment Act.
The motion is for second reading of Bill number 2. Is the House ready for the question? All those in favor of the motion, please say aye. Contrary, nay. The motion is carried.
Bill 92, entitled An Act to Amend Chapter 23 of the Revised Statutes 1989, the Assessment Act.
Order that this bill be referred to the Committee on Law Amendments. The Honourable Deputy Government House Leader.
Mr. Speaker, I'd like to call Bill number 94, Property Valuation Services Corporation Act.
Bill number 94, the Property Valuation Services Corporation Act. The Honourable Minister of Human Resources.
Thank you, Mr. Speaker. And Mr. Speaker, it is a pleasure that I stand before the members of the House to move this legislation, Bill 94, legislation to establish assessment services as a municipally controlled corporation, and bring this forward for second reading. This legislation will move Nova Scotia's property assessment services from the province to a municipally controlled, non-for-profit corporation. Mr. Speaker, since 2001, municipalities have paid for the full cost of property assessment, although services remain a division of the Service Nova Scotia and Municipal Relations. We have completed many reviews of alternative service delivery, however. These include an examination by assessment management boards of other assessment jurisdictions in Canada where the service is delivered outside the provincial government. The result of this work, Mr. Speaker, is the creation of a not-for-profit municipally controlled corporation. This corporation will work outside the direct operational control of the provincial government to deliver assessment services. The province will remain responsible for the legislative standards, for the separation of the tax policy and tax administration. As well, Mr. Speaker, staff from the department has consulted with mayors, wardens throughout the province and the Union of Nova Scotia Municipalities regarding the preferred option of the service of assessment services. At last year's annual UNSM meeting, a resolution was passed calling for the creation of an independent, municipally controlled, not-for-profit agency. The name of this agency, Mr. Speaker, is the Property Valuation Services Corporation. With a transition from government to a corporation, we are very mindful of the concerns of assessment staff as well. Mr. Speaker, it is our intent that all existing employees of assessment services will be transferred to the new agency. Employees will be designated to the new corporation through legislation, which will also include the protection of existing rights, terms, and conditions of their employment. Compensation is and will continue to be, Mr. Speaker, consistent with the collective agreement. The Public Service Award will be continued for eligible employees as well. Mr. Speaker, the proposed legislation will be proclaimed in stages. This means that the new entity, the corporation, will be established before designating employees. Therefore, employees will remain civil servants for a period after the corporation is established during the transition period. A new corporate structure will be created for support services such as human resources, finance, and legal services. Mr. Speaker, the corporation will be responsible to its stakeholders, principally the 55 municipalities under the direction of the Assessment Management Board. I now move for second reading Bill number 94. Thank you, Mr. Speaker.
The honourable member for Waverley Fall River Beaverbank.
Thank you, Mr. Speaker. One of the things that I've learned, certainly in the last 4 months, is that things aren't always as they appear to be. One of the things that I've learned to do very, very well, and I think I get better at it all the time, and that's try to listen to all sides. With this bill, Mr. Speaker, I do have some concerns. Having said that, I hope I remain with an open mind. When I looked at this bill and I look at the history and the track record between the province of Nova Scotia and the municipalities around assessments, it's sort of been, I don't know if we want to call it a football or a hot potato or what, but this is something that's gone back and forth 2 or 3 times, Mr. Speaker, over the years. And I guess when I see that sort of history and track record, one has to wonder the reasons why. Generally speaking, when I think of change, and when I think of change, whether it's related to government, whether it's related to a bill, whether it's related to whatever, usually change is supposed to be about for the better. And it's generally change is about improving the quality of services. And I guess I'm at a wee bit of a loss, Mr. Speaker, as to how this bill will improve certainly the quality of service when it comes to assessments. One of the things I think that will happen as a result of this bill, if it does pass, is that MLAs, myself included, will have that luxury of being able to say at some point in time, when we get that phone call about assessments, we can always raise our hands in despair and says, well, it's no longer our responsibility, maybe you should call your counselor. And it begs the question, at least for me, Mr. Speaker, to be asked, is why this process is in place to begin with. Now, I don't know, and I've been privy this year. I went to a conference by the Union of Nova Scotia Municipalities in Sydney. I listened to the Transitional Assessment Services make a presentation. I've talked even to some union representatives. And I'm not sure if this bill, this whole process, if it's the province downloading services to the municipalities or the municipalities requesting the services so that they can administer them. It may sound like a non-issue or a non-important point, but I think it's one worth raising. I wonder, when I was in Sydney, and I was there as an observer, and one of the things I found during my last 4 months, my first 4 months in the House of Assembly, is I find myself to be a good listener and ask questions sometimes only to myself or at the time that's appropriate. And I know on one day when they were explaining the assessment services technology, I know that as I was listening to how the technology was being rolled out, I was sitting there taking some notes, and in my notes there were a lot of questions that I had around the technology that potentially will be used for assessment services. And at that time, since I was a guest at the conference, I didn't think it was appropriate for me to ask the questions. So I continued to take notes, but when the presenters finished, much to my surprise, and I must say my pleasant surprise, some of the questions I had, the majority of the questions I had, were also those questions that some of the municipalities had. So I was able to set through a question and answer period, and I must say, Mr. Speaker, that even today, some weeks later, for me at least, some of those questions remained unanswered. When I hear of this assessment services and the transfer that being transferred to the municipalities, of course, one of the most important things I think about is the process, what the process was or was not that was employed as far as the transition goes of these services. There doesn't seem, when I read through this bill, and from what I've seen so far, there doesn't seem to be written anywhere, Mr. Speaker, a guarantee for discussion and negotiations, and I mean particularly with reference to employees and those representatives of those employees. I can see that this would raise some concerns with those employees, and it raises some questions, I think, at least from my perspective,